Sean has experience working at the British Columbia Securities Commission, where he negotiated settlements and appeared as counsel in commission hearings. He regularly acts for a number of national brokerage firms and their representatives in both civil and regulatory matters before securities commissions, the Investment Industry Regulatory Organization of Canada, and the Mutual Fund Dealers Association of Canada. Sean is a former chair of the Securities Law subsection of the British Columbia Canadian Bar Association and a former member of the Securities Law Advisory Committee to the British Columbia Securities Commission. Here to discuss the latest developments in Canadian securities class action law and their implications for U.S. companies is Sean Boyle.
Good morning. Morrison and National Bank of Australia. 40 years of lower court precedent swept away by the U.S. Supreme Court back in June 2010. Over the past couple of years, there has been a number of decisions and much commentary examining the consequences of the Morrison decision and commenting on the death of the conduct and effects test. This morning, I won't be drilling down into the minutiae of Morrison, and I won't be reviewing U.S. law to any great extent. Rather, I will be focusing on recent developments in Canadian courts as they relate to transnational class actions, and more specifically, to transnational securities class actions. Over the last century, there has existed close ties between Canada and the U.S. on many fronts, but in particular in connection with securities laws. Canada's 13 provinces, 3 territories, each have their own Securities Act, which operate, for the most part, harmoniously by way of a passport system. Likewise, for over 20 years, since 1991, both Canadian and U.S. public companies, cross-listed issuers, have been able to rely upon the MJDS, the multi-jurisdictional disclosure system, where they can use for Canadian listed companies, their Canadian disclosure to satisfy the U.S. requirements, and vice versa. U.S. listed companies can use their U.S. disclosure to satisfy the Canadian securities regulatory filing requirements. These ties or links between the two countries have continued into the courts and are found at the very early days of the pre-Morrison transnational securities jurisprudence. The first case in 1969 was Schoenbaum and Furstbrook. A U.S. investor brought a shareholder derivative action against a Canadian oil company. U.S. investor suing a Canadian oil company. The company's shares traded on the Toronto Stock Exchange and the American Stock Exchange as it existed back in 1969. The courts below in that case dismissed the action on the basis that there was simply a lack of subject matter jurisdiction. But the U.S. Court of Appeal for the Second Circuit held that Congress intended in the Exchange Act to have extraterritorial application in order to, quote, protect domestic investors who have purchased foreign securities on American exchanges and to protect the domestic securities market from the effects of improper foreign transactions in American securities. And then a few years later, in 1972, was the second decision of Leaseco Data Processing in Maxwell, which introduced the conduct test. And in Leaseco, the facts were it was an American company that had been fraudulently induced to buy shares of a British company on the London Stock Exchange. And there the court held that Congress would have, quote, wished the Exchange Act to cover such significant fraudulent conduct on its own soil. Now, I recite those quotations to highlight what the U.S. courts were saying in the late 1960s and the early 1970s, and as a foreshadowing of what the British Columbia Court of Appeal said 3 months ago in a transnational class action against the diamond giant De Beers in connection with its European and African companies. The law in Canada, the legal test, is whether the subject matter of the litigation has a real and substantial connection to the jurisdiction. This past spring, our Canadian Supreme Court of Canada released 3 very long-awaited, unanimous decisions that set out new approach to be followed by the courts in assuming jurisdiction over foreign defendants. The court's main judgment was actually a personal injury case where Canadian tourists suffered injury and death while vacationing in Cuba, and they sued the resort's Cayman Island-based hotel manager in Ontario, Canada. The other 2 cases of the trilogy involved multi-jurisdictional defamation claims. In articulating the test, the court identified 4 non-exhaustive presumptive connecting factors. 1, whether the defendant was domiciled or resident in Canada. 2, whether the defendant carries on business in any province in Canada. 3, whether the tort or the wrongdoing was committed in a province in Canada. And 4, whether the contract connected with the dispute was made in the province. These presumptions are rebuttable, but the court must assume jurisdiction if any one of them is met. In the securities class action context, we have the recent decision of Abdullah and Canadian Solar. This was a class action seeking relief under a statutory cause of action for misrepresentations provided for by Section 138.3 of the Securities Act, Ontario. Let me provide some background on that. In Canada, the fraud on the market theory, the efficient market, that was soundly rejected by our courts across the country. So between approximately 1995 and 1998, the various provincial legislatures enacted new legislation in the Provincial Securities Act, what we call secondary market liability provisions. These amendments to the Provincial Securities Act provided for deemed reliance, that if a reporting issuer or responsible issuer made misrepresentations, the issuer, the director's officers, the executives made misrepresentations, there was a defined class and they were deemed to have relied upon that misrepresentation. Likewise, as a legislative background, in Canada, all public companies are reporting issuers and have obligations to the provincial regulators in addition to any stock exchange that they may be listed upon. And indeed, there's reporting issuers whose shares are not listed on any exchange, but that company still has all of the continuous disclosure obligation, all of the filing requirements that a publicly traded company would have. And with that legislative background, I want to turn to the facts of this case. Mr. Abdullah was a resident of Ontario who sought to rely upon this statutory cause of action. So not a common law claim, but a statutory cause of action with deemed reliance under Section 138.3 of the Ontario Securities Act. He claimed and sought a class proceeding on behalf of a class who relied on misrepresentations with the company's filings with the SEC. Now this company, Canadian Solar, place of business was in China. And this is a matter of really form over substance. The substance of this company carried on business in China. It was, however, a registered Canadian corporation. So it had a registered and records office through an attorney's law firm in Canada, but principally it was a Chinese company doing business in China. The company's shares were traded on NASDAQ and on no Canadian exchange. It was not a reporting issuer in any Canadian jurisdiction. It had no securities obligation in Canada whatsoever. No filing requirements, nothing. All of its securities obligations, all of its reporting obligations, all of its filing obligations were with the US SEC. The issue on appeal was whether the term in the statutory liability provision, responsible issuer, which included by definition any reporting issuer in Canada, which Canadian Solar was not, and any issuer whose securities are publicly traded. So the issue for the lower court and the Court of Appeal and soon to be for our Supreme Court of Canada, was, can the courts read in, and did the legislature intend it to be securities publicly traded in Canada or anywhere in the world? The takeaway from this decision is that any public company can be a defendant under the various deemed reliance provisions of Canadian Securities Act if any one of those presumptive factors are met. So the courts here concluded that despite the fact that there was no reporting obligation, no securities filings in Canada, and in fact the Canadian lawyers for that company would not even consider that there was any obligation to comply with Canadian securities law, the courts have found that there is indeed jurisdiction to pursue these statutory remedies under the Securities Act in Canada. The Fairhurst and De Beers Canada decision is a decision of the British Columbia Court of Appeal from June 14, 2012. This was a proposed class action alleging that over a 10-year period, the proposed class purchased hundreds of millions of dollars of gem-grade diamonds manufactured and distributed by the defendants, and that those same defendants conspired to fix prices illegally, to control, to restrict the supply of diamonds on the world market, and thus inflating the price. And the plaintiffs there allege that that was contrary to common law claims, but also under the Competition Act. The citation of this case, and that's the official citation, is actually quite misleading because it principally involves 6 other defendants, 6 other companies. And those companies are De Beers Investment, Inc., Luxembourg, De Beers SA, Luxembourg, De Beers Consolidated, a publicly traded company in South Africa, 75% of the shares of which are owned by one of the other private De Beers companies. The Diamond Trading Company Limited out of the UK, that's the entity that would buy the production from the diamond mines around the world. And then De Beers Century AG, a Swiss company, and CSO Valuations AG, another Swiss company. The evidence was that De Beers Canada owned some mining claims up north and had never sold rough or polished diamonds in Canada ever. Uncontroverted evidence. But despite this evidence, the court concluded that, quote, a corporation need not carry on business in British Columbia to affect prices illegally in the province. And accordingly, there was a real and substantial connection. I've included this case, which is a regulatory action involving insider trading allegations, for a couple of reasons. First, it's consistent with the expansion of jurisdiction that we've seen on the civil front and on the class action front. But I wanted to highlight for this crowd, this FINRA conference, that this expansion is also seen on the regulatory field as well. The subject matter, Mr. Torredag, was a resident of Quebec. And in Canada, with our 13 provinces, like the state, we have individual provincial jurisdiction with the Provincial Securities Act. And Mr. Torredag, a resident of Quebec, had a Luxembourg company that conducted the trading in this issue. And this Luxembourg company had a brokerage account through a broker-dealer in Connecticut. And Mr. Torredag, through his Luxembourg company, through a broker in Connecticut, was on his laptop engaging in what was found to be illegal insider trading. The uncontroverted evidence there was Mr. Torredag had never been to British Columbia, had no interest in going to British Columbia, and but while he was engaged in his illegal insider trading, purchasing the securities through the exchange, through the open market, of course having no knowledge of who was on the other side of the trade, the sellers on the other side of the trade happened to be, in the majority, BC residents. So despite the fact that Mr. Torredag would have no knowledge of who he was purchasing securities from, they happened to be BC residents. The company that he was purchasing in, the listed issuer, was a BC reporting issuer. It was a reporting issuer in a number of provinces. And on the issue of jurisdiction, which went to the Court of Appeal, and leave to the Supreme Court of Canada was just denied a few weeks ago, the court said, fair enough. There is a connection. There is a real and substantial connection. And the court there said it doesn't have to be a meaningful connection. There just has to be one of the presumptive factors, one of the connections. And the takeaway from this I wanted to highlight for this crowd is that if you or your clients step onto the playing field in Canada, in British Columbia, in Alberta, in Ontario, whether inadvertently or otherwise, they can expect to be regulated. And that's with licensed broker-dealers in New York, and this is common, who happen to have 6, 12, 24 clients in British Columbia, Ontario, or elsewhere, find themselves, inexplicably to them, being regulated by this foreign regulator. And it's our courts have been saying that, not unlike the history of jurisprudence in the United States, that if you step into our markets, if you step onto our playing field, you have to abide by the rules of the game. At the outset, when I referred to the quotations of Schoenbaum and Leasko, this is what I had in mind. And you'll see in Morrison, the courts have now said, no, we're going to draw a bright line. We're going to draw a bright line as to when as to the jurisdiction of this court, and that it's going to be a rare case where there's no connection whatsoever with the territory of the United States. The De Beers quotation to me is the most interesting, and that's where our Court of Appeal said it may seem inconceivable to the large European and South African corporate defendants in this proceeding that, in the phrase of Ms. Kay, they are being called to the court of a jurisdiction on the far side of North America that seldom, if ever, figures in their decision-making. However, consumers in this province, no less than other jurisdictions, may be affected by conduct of the kind alleged by the plaintiff. The territorial competence of British Columbia courts over the defendants is the result of the operation of objective rules of territorial competence that have been formulated to reflect the realities of modern commerce. I was struck when I was preparing for this presentation that we have the death of the conducts and effects test here with Morrison and National Bank, but here we have, less than 3 months ago, one of the top appeal courts in Canada referencing the affected and conducts test in Canada. Likewise, in Morrison, the court commented that summed fear in arriving at their decision that the U.S. had become the Shangri-La of class action litigation for lawyers representing those allegedly cheated in foreign securities markets. And so I query whether Canada is the new Shangri-La, and for whom. Some might argue it's the Shangri-La for plaintiffs. We have very low thresholds for certification, and we have a number of no-cost jurisdictions. There is, however, a contrary view, and it's arising from, among other things, the Silver and IMAX decision. And that's where the courts in Canada now have been certifying global classes. And if the Canadian courts continue to certify global classes, U.S. investors may find themselves subject to a Canadian class action. And is that a bad thing? Potentially not. Some companies may complain, but in Canada we have historically smaller damages award, non-existent punitive awards, and the lack of jury trials. And it may give rise to a res judicata claim in any future U.S. proceeding. In conclusion, it's clear that as the U.S. is exiting the global securities litigation playing field, Canada is running onto the field and calling for the ball. Thank you very much.